Okay, it's kind of funny, but it's not funny. So I keep trying to get this case scheduled for a plea. And what I think is happening is they see that he has a felony pending and they keep resetting it on their own motion.
Which court is this?
12, Judge.
Who's 12?
Judge Huff. And I've explained to Booker, and I'm not throwing him under the bus.
No, throw people under the bus who need to be thrown under the bus.
Well, that
Just make sure
it
it's
is
not
of paramount importance that we get this plea done and they continue. I think he's just brain farting on it and he keeps resetting it because
What?
of your case. Brain fart. I don't.
Is that illegal?
Yes, it's a term of art, Judge.
No, it's
So-
not a term of art.
So
Jenna Rodriguez. All right, why were you late for court?
The list was really made.
All right, let me just tell you this. Everybody has heard this story from me before. It's a true story. I used to take the bus and I had clients who would be at court for me at 9 o'clock. And to make sure that I was here on time for the court, I would catch a bus and I would end up getting to court as early as 7 a.m., sometime late as 7:30 a.m. And the court didn't open till 9. So you need to make sure that you're on time for court. If you're not on time for court, then what's going to end up happening is we will help you be on time because the bus schedule from the Bexar County Jail, it usually runs on time. And I usually know where people are when they're at the Bexar County Jail, and you'll be brought over in a blue outfit and we'll hear your case while you're in custody. Do you understand? All right. So where are we on this case?
Your Honor, the state's made an offer. I haven't conferred with defense since we made the offer.
We just want a regular reset to go over the offer and everything and come back with the,
Do you have all the discovery?
yes, I do.
Have you tendered the offer to your client?
Yes, I have.
Is there going to, Ms. Rodriguez, are we going to have any issues with you with drug testing? Are they going to be clean?
Should be clean.
What does that mean? Should be. Because here's the thing, I'll have you tested today. I have some concerns. So if I drug test you today, what are the results going to be? What could it possibly be? Here's the, okay,
Marijuana. I asked the same question. There's a possible.
marijuana and what else? What have you used in your past life? Now, here's what everybody will tell you. I'm sure your attorney has told you. You're here for a theft case. And from speaking to you, it appears that there are other issues that are going on in your world.
Yeah.
And I'm trying to figure out what those issues are. You understand? All right. So I don't know what you're using. I think it may be more than marijuana. I'm going to give you your reset, but let me forewarn you. Whenever you take a drug, whatever it may be, there's always a chance that that's the last time you're going to take that drug because you may end up having an overdose. So when you leave from this court today, your best options for your best life is to go to an NA meeting or somewhere so people can help you. You understand? All right. Ms. Ferguson, can I have a 2-week turnaround on this for a plea deadline date? All right, we're going to come back on October 21st. That's going to be your plea deadline date. At that time, you need to let me know whether or not you're accepting the state's plea bargaining agreement. You understand? All right, the only reason why I'm not pushing this case today is because I think you need help with your attention, and I think that can be accomplished in 2 weeks. So make sure that when you leave here today, that you go to an NA meeting. They have NA meetings all downtown, so you can walk to it. You don't even need the bus. You understand? And counsel, can you let her know where the NA meetings are located so she can go to that? All right. Do you have any children at home?
I'll start this Friday.
Okay. All right. Take care of yourself. Okay.
Excuse?
Yes.
26 because they wanted that attorney first, like we moved to that.
Yeah. motion to plead on the matter.
All right, the court is calling 2017 CR 9939, State of Texas versus Barbara Shorey. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
David Clare.
And are you Miss Shorey?
Yes, sir.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Okay, you're going to need to speak up, okay?
Yes, sir.
Are you the same Barbara Shorey who was placed on community supervision in 2017 CR 9939 for the offense of robbery on June 21st, 2018 for a term of 6 years? Is that you?
Yes, sir.
State?
Condition number 5, in Bear County, Texas, the defendant Barbara Shorey did then and there fail to report to the supervision officer as directed for the months of July and August of 2021 in violation of condition number 5.
How do you plead to that, true or not true? I'm sorry,
True.
state?
Judge, we'll waive the others.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 5, the court can find it true, grant the motion, sentence you to 8 years in prison and up to a $1,500 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court is finding violation of condition number 5 true. Is there an agreement?
There is not, Judge.
All right, state, what are you requesting?
Judge, we are asking for revocation. This appears to be at least a fourth NPR. I mean, it looks like she's pled true to number 5 at least 3 times before. So she's shown that she's not a good candidate to continue probation. So we're asking that you.
Now we move into a much more serious situation. Barbara Shorey is before the court on a motion to revoke community supervision, and that phrase matters. Community supervision is essentially probation, and a motion to revoke means the state is asking the court to take that probation away and impose a sentence instead. The alleged violation here is failing to report to the supervision officer for July and August of 2021. The key moment is her plea of true. That is not the same as a trial verdict, but in this context, it means she is admitting the violation. Once the judge finds that violation true, the court has the authority to revoke probation and sentence her within the available range. And the state immediately points out this is not the first time. They say it appears to be at least a 4th motion to revoke, with multiple prior failures to report. So the stakes are no longer, did something happen once? The issue becomes pattern. How many chances does someone get before the court says probation is no longer working?
Revoke it.
Defense?
Your Honor, Barbara's just asking for another chance. I think the state, the probation office is recommending continue with some other conditions, and we'd like to consider that at this time.
But why should I?
Well, she has a long probation and she has children, and the probation office is recommending safety, so maybe the additional treatment will help her, get on the right track.
All right, Ms. Shorey, is there anything you wish to say? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, yes, ma'am.
All right, you can lower your hand, state your name for the record.
Barbara Shorey.
All right. You want to explain to the court why you haven't been showing up?
But this last time.
Okay, you need to lower your mask so that we can hear you.
I'm sorry, ma'am, it's because I'm quarantined for COVID right now.
Oh,
I'm
well,
under
put the mask on,
That's all I'm saying.
but you need to speak up.
Okay. Well, this last MTR, I did report, I went to the office and they told me to leave the office because I had told the security that I had been exposed to COVID.
Well, see, here's the thing. The problem is you never show up. And when I say never, of course, I don't mean every single time, but I will tell you every motion to revoke we have for you, it's because you're not showing up.
I did show up this last time, ma'am, but they asked
No, you just pled true to
Yeah.
not showing up.
they asked me to leave the office, and I stepped outside and I spoke with my probation officer. She asked me to go get COVID testing, and I did, and I was positive for it. And I have proof with my daughter-in-law and my granddaughter.
So did you have COVID in July? Did you have COVID in August?
Yes.
Okay.
Yeah, well, no, July, I've had it in September, in August and September.
So you
I
didn't
went
have
to
it in
report
July?
August, I'm sorry. I got out July 28th. I was released, And then in August, I was reporting, and that's when I went to go report. They asked me to leave the office. When I left, I called her and I spoke to her outside. I said, ma'am, I'm right outside your office. Can you see me, please? She said, I want you to go get tested for COVID. So that's what I did. I went and got tested for COVID, tried to, contact
So is
her.
there documentation for that?
Well, I have documentation at home.
No.
Not-
I mean, we're here today for a
Yeah,
hearing.
She never answered my calls. She just MCR'd me.
Well, here's the problem. You were placed on probation on June 2018. That was before my time. But during my time, you were brought to court on March 5th, 2019 for not reporting. And so your conditions were altered and amended to include McMiles evaluations. And you had a TAP evaluation. Then we come back on May 21st, and there's a new number 5, which means you're not reporting. Then we come back on May 17th, and it was recalled for May 18th. And then it was recalled for May 21st. Then we come back on May 21st, and it's not reporting. And now we're here for not reporting.
I understand. Next week.
Yes.
Okay, the first MCR, my mother was very sick and I had to take care of her. I went through a lot of stuff with her. The next one, I got my kids back. And, then, like, I've had 2 of my daughters raped and I've been going through the process of CPS, which CPS has been involved in, where I've been staying with my mother and with my children and trying to get me back because I do not have rights to them because my rights were terminated. So after 10 years, their father, he abandoned them and then they were with their grandfather, which ended up molesting them and physically abusing them. And this has all been documented. And, I was just trying to,
Okay, see, that's your, and let me just tell you, you know who's the cause of that? Not of the fact that offenses were committed against them,
Yeah.
but their problem is they don't have a single parent who's watching out for them. They have a parent, which is you, who commits robberies and does not report for probation. And again, this is the 3rd time, I believe, that we've been here for you not reporting. So
This is where the emotional tension gets heavy. Ms. Shorey brings up family struggles, her children, her mother, and serious allegations involving what her children experienced. Those are painful facts to hear, and the judge does acknowledge sympathy. But Judge Boyd also separates sympathy from legal responsibility. That distinction is crucial. The court is not saying trauma does not matter. The court is saying trauma does not erase the obligation to report while on probation for robbery. And when the judge says the children do not have a parent watching out for them, that is one of the harshest moments in this hearing. It lands hard because the judge is tying the repeated probation failures to the defendant's larger responsibilities as a parent. This is the moral collision in so many revocation hearings. A defendant may have genuine hardship, but the court still has to decide whether repeated noncompliance can continue. So what do you think? Should the court weigh her personal circumstances more heavily? Or is the repeated failure to report enough to revoke?
I'm going to grant the state's motion. So the question is, state, how much time are you asking for?
Judge, the underline is 8, so we're asking for 8.
Defense?
We're asking for 2 at this time.
All right, Miss Shorey, what should I sentence you? You're looking at 8 years. And that's what the agreement was, for you to do 8 years in prison if you didn't successfully complete probation, and you have not successfully completed it. So I'm granting the state's motion. I am going to revoke you. The only question is, how much time should I give you? So how much time do you think you deserve?
I've already had all this time taken away from my kids. So at this
Okay,
point,
they are children.
Yeah.
They're not kids. And number 2, the reason why you've had time away from your children is because of you. It's not because of me. It's not because of the state. It's not because of your defense attorney.
Yeah, it's because of my past, because my my ex-husband and student being in a physical relationship, physically abused and emotionally, and mentally, like, him and his family.
What does that have to do with the fact that you're on probation for robbery? I'm sympathetic to your plight. I'm sympathetic to people who have been victims of abuse. I've had people in my family who have been victims of abuse, so I'm sympathetic to you.
I understand. that.
But my question for you is, you're looking at 8 years in prison. The state wants you to do the full 8, which is a part of your contract. Your defense attorney wants you to do 2. My question is, what do you think you deserve?
I just think I deserve. Whatever you define me, Judge. Define me, Judge.
Okay. All right. Did she ever pay the restitution of $175 to Rosemary Mauricio probation? And did she complete any courses? Did you complete anger management?
I'm not sure if I took the class here when I was.
No.
Yeah.
Did you know if you completed anger management or not? Did you?
I'm not sure. ma'am.
Probation, did she complete anger management?
No, yeah.
Did you pay the $175 to Rosemary Mauricio? So let me ask you this. What have you done since you've been on probation other than not report? Have you done anything?
I was trying to get my kids situated and.
Children, they're not kids. Kids are billy goats.
For my
So-
children, yes, my children, I'm sorry.
Okay.
What have you done since you've been on probation other than not report? Name me one thing that you have actually done, started or completed while you've been on probation.
From my probation.
Yes.
Honestly, it's right there. I haven't,
Have you done anything?
besides have being employed, I mean, that's all I can, that's all I can say.
Okay, so you've done nothing?
She's done a top evaluation and she did a mental health evaluation, but only the evaluation was completed.
No follow-up from her?
And then she's only paid a total of $92, 88 of which went to one of the rest.
Okay.
We had one negative drug test also. We haven't.
Okay. So there is to be $87 restitution to Rose Marie Mauricio. And are you expecting or no?
No, ma'am, I'm sick from my liver. I have
Okay.
cysts.
Okay. All right. They will make sure you let them know at the jail and let them know at the prison that that's an issue so that they can give you treatment for that. Okay.
Yeah, I have to.
All right. The court is going to sentence you to 6 years in the prison. Give you credit for any time served.
The sentence comes down 6 years in prison with credit for time served, plus no contact with Rosemary Mauricio and her family or residents. That is less than the full 8 years the state was asking for, but far more than the defense request of 2 years. So in a way, the judge lands between both sides. She grants the state's motion, revokes the probation, but does not impose the maximum available sentence. Before that, the court also walks through what Ms. Shorey did or did not complete on probation: restitution, anger management, evaluations, follow-ups, and reporting. That matters because revocation is not just about one missed appointment. The judge is looking at the full record of compliance. And when the answer to "what have you done" is unclear or minimal, it weakens the argument for another chance. This is a brutal but important reminder. Probation is not passive. It requires proof of effort, proof of compliance, and proof that the person is actually using the opportunity the court gave them.
There's to be no contact with Rosemary Mauricio
Well, he went through all that.
and her family or her residents. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is, you do have a limited right to appeal. I'm sorry, could I see that again, please? You do have a limited right to appeal. And that right to appeal is as it relates to the allegations, not the fact that you're on probation. Do you understand?
And then we are.
Your attorney will explain to you the appeal process. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, yes.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, yes.
All right, good luck to you. We can go off the record. Here's the thing, Ms. Shorey. It appears that you may have a drug or major alcohol problem. You cannot be in your children's lives and actively be there if you don't take care of yourself first. And that means getting your drug issues under control, taking care of your mental health issues, taking care of your medical health. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank-
You're welcome.
God
Who's
bless
here?
you.
And I remember when it was 1980, we thought, oh my gosh, it's 1980. Now, look at us now.
I won't say what I was gonna say, so.
Oh, but I know what you were thinking. Yeah,
Why is the color so off on the TV?
It is very.
I have no idea.
Because you were getting it's somewhat to a Hulkish tone up there, like it's green.
It's like I'm agreeing, maybe I'm with the Great Gazoo from the Flintstones. That's my childhood.
Well, that's why I'm going. It's Halloween this year.
Oh, you are?
I'll be Fred.
Okay.
Oh, really?
Jorge's being Barney Rubble.
Oh.
Yeah.
And are you April Sanchez?
Yes, ma'am.
All right, I'm going to show you a document entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same April Marie Sanchez who was placed on community supervision in 2020 CR 2524 for the offense of felon in possession of a firearm on July 10th, 2020 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Judge, violated condition number 5. In Bear County, Texas, the defendant April Marie Sanchez did then and there fail to report to the supervision officer as directed for the months of January and February 2022 in violation of condition number 5.
How do you plead to that? True or not true?
We'll waive all other violations, Judge.
Any objections to the state's waivers?
No, no, Your Honor.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
I'm sorry, that is incorrect. You're on regular probation. Did you understand that the court could sentence you up to 3 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? No.
I didn't hear you.
So let me explain it. So you pled true to violation of condition number 5. Do you understand?
Yes.
All right. Now, I can find that true and I could sentence you up to 3 years in prison. I'm sure your attorney
Oh, yeah.
and the state probably have an agreement worked out. I don't have to accept that agreement. And I will tell you, in this court, if I don't accept the agreement that's been worked out, then I will let you know. And even though I don't have to, I would give you a chance to work out something else if I don't accept the agreement. You understand?
Yes, ma'am.
So do you understand that by pleading true to violation of condition number 5, I could find it true and sentence you up to 3 years in the prison? Did you understand that?
Yes, ma'am.
And up to a $1,500 fine.
Yes, ma'am.
Knowing that, do you still want to plead true to violation of condition number 5?
Yes, ma'am.
All right, the court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge, we're asking that you revoke her probation and sentence her to 2 years in TDC.
That is the agreement, Your Honor.
All right. Ms. Sanchez, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Right. All right, the court will follow your agreement. The court will grant the motion. And the court will sentence you to 2 years in the prison. There's a $1,500 fine, time and money to run concurrent. Court will give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain, you're welcome. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I see that I'm the one who set your conditions, and part of the conditions I set for you was CPS compliance and parenting classes because you had children, and treatment for your drug issues. You haven't been successful on this probation. Let me tell you something. When you get out of prison, do not go, if your family member has custody of your children, do not go knocking on their door, trying to take over and be a parent. Because let me just tell you, if Child Protective Services has said that we're giving your children to your relative and you show up and you live there, you're going to be opening your children up to be removed from that location. You understand? And I think you would agree with me that at this stage in your life, you're not the best of parents for your children, right? So when you go to the jail, and I will ask for therapeutic community for her, it won't extend length of time you are at the prison. But when you go there, you need to take advantage of all of the treatment they have available. You understand? And when you get out of jail, the immediate thing you should do is not call your children, not call who has your children, but you should be finding a rehab treatment facility. And they have them here throughout town and they're free. Okay. All right. So I'm going to add therapeutic community for her.
April Sanchez's hearing is shorter, but it carries its own weight. She is on community supervision for felon in possession of a firearm, and she pleads true to failing to report for January and February 2022. There is an agreement: revoke probation and sentence her to 2 years in prison. The judge follows that agreement, which is why the appeal rights are limited afterward. But then Judge Boyd goes off the record and gives the part that may be even more important than the sentence. She talks about CPS compliance, parenting classes, treatment for drug issues, and the reality of what Sanchez should do when she gets out. The judge specifically warns her not to disrupt a family placement if relatives have custody of the children, because that could risk the children being removed again. That is not just legal commentary. That is practical life advice from the bench. The sentence is 2 years, but the message is bigger. Do not come out and repeat the same instability that helped create the case in the first place.
All right. Good luck to you.
Ma'am, does that keep my back time and all that? And,
You get credit for any time that you've been in custody.
and what about the authorizing the vehicle and the other
I'm
count?
sorry, what?
The other charge I have and the other count?
No, I'm not in charge of that. I'm just in charge of what is here. Okay.
Norma just said it's 229 days.
Okay. She'll receive credit for that.
Yes, thank you. And
All right.
excuse
Yes, you may. Always a pleasure seeing you. Have a good one.
me, Judge.
All right. So, Ms. Connor, do you know why you're here? Yes. So what are you not doing that you're supposed to do? I'm sorry. You need to speak up. No, let me just tell you the report I've received. One, there's an issue with your testing positive for marijuana. You can unfurl your arm. So why are you testing positive for marijuana? No, I mean, you are, it's not a matter of you shouldn't be, you are testing positive for marijuana. So I'm trying to figure out why you're testing positive for marijuana. Are you pregnant? All right. So obviously you keep rubbing your stomach. You want me to know you're pregnant. So I've taken note of the fact that you're pregnant. So my question is, why are you using marijuana when you're pregnant? No, you're still doing things. I mean, this is what ends up happening in court all the time. People want sympathy from me and mercy from me because they want to come in and let me know they're pregnant by rubbing on their stomachs and all of this. And then they're not doing things to protect their child by using marijuana and by not taking a UA when the court tells you to take a UA. So those are issues. Now, when you do a UA today, because you are doing one, everyone needs to lower your voice. When you do a UA today, because you are going to do one, what are the results going to be? All right, you're going to do a UA today. And the other issue I have, which I don't understand, the field team visited your home or where you were living. There were 3 small children in the home, ages 3, 2, and boyfriend's older child from previous relationship was in the home at the time. So why are there so many children in this home?
Son was visiting and the 3 toddlers are mine.
So you have 3 toddlers. How long have you known this boyfriend? Okay. And how is your Child Protective Services case going?
Fine.
Have you been in contact with your worker? Where are you currently living? No, that's not my question. My question is, where are you currently living? So you're not in, are you in Bear County? Did I give you permission to leave Bear County? No, my question is, did the court give you permission to leave Bear County? That's either yes or no. Your contract is not with probation. Your contract is with the court. So I didn't give you permission to leave Bear County. And the fact that you have so many children living in your house, obviously someone has to do something to protect the children who are living in your house. And the way that is accomplished is by me requiring probation to do field visits. And you are actually on probation for injury to a child by omission. And the facts of that case are the same thing that's happening in this household right now. You got children who are living there, parents who are using marijuana, whether they think it's legal or not, and constantly bringing more children into a situation when you don't have stable housing. I don't understand why people do that. You know, you don't have stable housing. You have a 3-year-old, 2-year-old pregnant, and then your boyfriend has another child who's coming to visit. People keep having children and bringing them into unstable situations. It amazes me that somebody would make the conscious decision to have a child, and now you're living in an Airbnb, don't have a place to stay, you're on deferred adjudication, using marijuana, moving to locations without getting the court's permission. Did you give your CPS work? Did you tell your CPS worker you're going to be moving? All right, Ms. Loper, are you the CPS worker in this case? You're muted.
Yes, I am.
Are you the CPS worker in this case?
Yes, I am.
Your volume's not on.
Okay, yes, I am.
All right. Are you aware of Miss Connor moving to another location, not in Bear County?
I knew that her boyfriend got a job in Austin, but they were supposed to let me know so that I could transfer the case to a worker in Austin.
So that's either, did you know she had left or did you not know?
I did not know.
Mhm. All right. And then let me just tell you the report I got from October 5th, what you're bringing your children to. Field team made contact with the defendant, and the following information was noted. Upon entry, the sofa was blocking the front door to prevent the children from walking out, which means that children are not being supervised if you have to put a sofa to block the front door. In the living room, there was a mattress and scattered mess all over. Her daughter was watching TV in the living room. In the front room were her two boys behind a closed door playing on a foam mattress. There was no furniture and the room was a mess. The boys walked out once the door was open. In the back room, there was furniture and personal belongings scattered around the room. In the guest restroom, there was also a scattered mess all over. Defendant was advised CSO would be visiting frequently as ordered by the court. Defendant is aware her residence needs to be organized and clean. Defendant stated she is aware the residence is a mess and has not had time to clean, but will. Defendant stated she is not employed at the moment and currently pregnant. So why do you have your children living in a unclean home?
I had told them. The one who couldn't from her dad. So things were a little messy on top of his son coming over and visiting and stuff. And when they came the next time, everything was clean. They even said something about how they had seen an improvement on the mess. So.
All right, I want a UA today. Do you need any water? That's either, if you need some water, we'll make sure you have water. Do you need any water? All right, so I'm going to want a UA today.
This next section is intense because the focus shifts from missed reporting to child safety. Ms. Connor is pregnant, testing positive for marijuana, apparently living outside Bexar County without court permission, and there are multiple children in the home. The judge is not treating marijuana as a minor issue here because probation rules matter, pregnancy matters, and the underlying case is injury to a child by omission. That last part is critical. The judge says the facts of the original case resemble concerns now being raised in the household. Children in an unstable environment, marijuana use, and questions about supervision. Then the field visit description makes things worse. A sofa blocking the front door, scattered mess, children in rooms, and concerns about cleanliness and organization. Whether you agree with the judge's tone or not, legally she is focused on risk. Probation is not just about avoiding new crimes. It is about complying with conditions and reducing danger. And here, the judge sees red flags everywhere.
And we're going to do it in court today. And then we're going to come back after I get my result. All right, Ms. Loper, if you want to, we're going to see what the result on this UA is, and then we'll go from there.
Okay,
Thank you.
thank
I'm
you.
going to put you in the rating room.
Okay.
All right, according to probation, you're positive for marijuana. I'm not allowing you to transfer to Austin, so whatever job your husband has, you need to be here in Bexar County. And probation, I want those field visits done 3 times per month, randomly, until further notice, so we can make sure that the children are okay. So I don't know what's happening in your CPS case. I deal with the criminal side, not the civil side. They're allowing you to go to Austin. I guess that's what they're allowing. I'm not allowing it. If you want to be allowed to live in Austin, then you need to do better on your probation. And better on your probation is not having a house that, from the reports I'm getting, is messy with couches blocking doors and you testing positive for marijuana and being pregnant. And so that means that either you are using marijuana outside your house, in which case the children are being unsupervised, and that would explain the couch blocking the front door, which is a fire hazard. If there's a fire in the house, how do you expect firemen to get in the house when you're blocking it with couches? And if your husband or boyfriend or the father of your children doesn't want to step up and help you if you have medical issues, then maybe you shouldn't be in a relationship with him. But you are setting a horrible example for your child. And I don't know about this other mother who lives, who knows where, allowing her 9-year-old to come and stay with you, who is on probation for injury to a child by omission. People need to stop letting their children just stay with random people that they don't know and they don't know how they're living. So CBS can do whatever they wish, but I'm telling you right now, your probation is not getting transferred to Austin. You're not allowed to live in Austin. you're going to be living in Bear County, and this court is going to have to keep an eye on all of these children who are under the age of 3 and the 9-year-old that some parent somewhere seems okay with allowing you to supervise. So probation, she's not to be in Bear County.
Yeah, yes, Your Honor.
And if you live in Bear County and you leave this county to go when I didn't give you permission to, a motion to revoke is going to be filed. Is there anything else?
Your Honor, a TAP evaluation was revised to, for a recommendation of safety. I don't show that on here that she has a condition for any type of outpatient treatment at this point. If you're not going to do a residential mandate, can we ask for intensive outpatient
Yes,
treatment?
intensive outpatient treatment. And I'm going to want her tested for levels.
In addition, can we set a, maybe a clean date or?
Well, if her levels are increasing, file a motion to revoke. So if your levels increase, a motion to revoke is going to be filed. And let me just tell you something. People think marijuana is okay, but let me ask you this. Is it okay for your 3-year-old to smoke marijuana? Do you have any problem with that?
Of course.
All right. So the child that you are carrying, that you keep rubbing your stomach and you want me to know you're pregnant, guess what? When you're smoking marijuana, you're letting an unborn child smoke marijuana. Just imagine that child in your stomach, kicked back on a couch, smoking marijuana, because that's what you're doing. Do you understand? I'm not going to tolerate that, because use of marijuana is not allowed on probation out of this court. And if your levels rise, we're not going to have a compliance hearing. We're not going to have a conversation. I'm going to get notice that your levels have gone up and a motion to revoke is going to be filed. And wherever you may be, at your home or in the grocery store at HEB or wherever it is, a warrant's going to be issued. And if police see you there, they're going to arrest you because you're pregnant. They will handcuff you in the front, which they're supposed to do. And you will be taken to the Bear County Jail. And while you're at the Bear County Jail, you will either make bond or you will not make bond. If you don't make bond, you will be brought over to sit in the box as you see other people, and we will have a hearing on what to do. And what to do may end up you going to prison for up to 10 years. Do you understand?
How often would you like the UAs?
I want it at least once a week, randomly each week. And so do you still want to pretend to me like you have not been smoking marijuana?
I'm doing anything, Your Honor.
Okay, she's still pretending. So I want UA randomly once a week throughout the week.
Okay.
All right, thank you.
Thank you, Your Honor.
CPS, is there anything else you need?
No, there's not.
Yes. All right, Adriana Harrison. And is there someone from the state?
Yes, sir.
All right, what is happening with this case?
Judge, she has 3 new arrest cases, and then there's 3 sealed at large cases. Mr. Cox doesn't have, I guess, the discovery on all of the cases because all of them haven't been indicted. None of those new cases have been indicted yet. So I'm in the process of right now downloading onto a flash drive the reports and the photographs as it relates to each case, so that you can review that discovery.
Okay, so when is that going to happen?
As we speak right now, Judge, I'm downloading it on the flash drive.
And what are the alleged new cases?
So they are one assault, family choking, 1 burglary of a habitation with the intent to commit assault, 2 violation of bond or protective order by assault or stalking, and then 2 continuous family violence cases.
Okay. And so obviously someone else set bond in those cases and not me.
Yes, Judge.
All right. All right, Ms. Ferguson, I want this set for a contested hearing, and there will be no further resets for this contested hearing. Can we do this mid-November, please? Okay, then she'll be going into custody.
I know, I just did mine.
Here's the thing, I'm not in charge of whether you have a warrant or not. And your attorney will have a chance to check on that. So what date, Ms. Ferguson? November. All right, Mr. Cox, we'll be back on November 15th, and if you'll speak with the clerks, they'll find out why there's a warrant.
What a docket. Across these hearings, the theme was painfully clear. Probation is a second chance, but it is not a free pass. Ms. Rodriguez received a reset and a warning, with the judge urging her to seek help before substance issues become something worse. Barbara Shorey's probation was revoked after repeated failures to report, and she was sentenced to 6 years in prison with credit for time served. April Sanchez accepted an agreement for revocation and received 2 years in prison, along with a stern warning about treatment, parenting, and not disrupting her children's placement. Then Ms. Connor's case brought the court's focus squarely onto child safety, marijuana use during pregnancy, unauthorized relocation, and the court's refusal to transfer probation to Austin. The broader takeaway is that Judge Boyd is drawing a hard line between hardship and accountability. Personal struggles may explain behavior, but in this courtroom, they do not automatically excuse repeated noncompliance, especially when children may be affected. Now, we want to hear from you. Was the judge too harsh, or exactly what this docket needed? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.